Hi, I'm Kirsty Rayner, founder and solicitor director of Rayner's Lawyers. I am a highly experienced wills and estates lawyer who has undertaken several years of additional tertiary education on top of my law and commerce degree to obtain my master's in wills and estates law. I am truly passionate about this area of the law, and today I want to share one of my favorite estate planning tools, the Testamentary discretionary trust will. Now, I appreciate that's a bit of a mouthful, and to put it in as simple words as possible, it's simply a trust set up in your will that only becomes operational when you die. In this video, I will refer to a testamentary discretionary trust simply as a TT. So, why do I love TTs so much? Because they are amazing for asset protection and tax flexibility. What do I mean when I say asset protection? I mean protecting your inheritance for your loved ones. For example, your partner or your child's future relationship breakdown, a bankruptcy, or their financial immaturity. I'd like to point out that financial immaturity extends beyond minor children. It can include spendthrift loved ones, those with gambling or drug addictions, and loved ones with disabilities. Leaving your inheritance in a TT is all about quarantining the assets you have worked hard to acquire to ensure they don't automatically end up in the hands of your loved one's future ex or a creditor, such as the trustee in bankruptcy, or blown away on drugs and gambling. Importantly, TT wills are not just a tool for the wealthy. Even if all you own is your own home, you should still consider upgrading your standard will to a more sophisticated premium will that protects your assets and reduces unnecessary tax. You've worked hard to build what you have, and when you consider superannuation and life insurance, you could be worth more than you think. Let me show you how you can protect your wealth and your loved ones by incorporating a TT into your will. And the best way to demonstrate the benefits of a TT is to compare it to a standard will using two case studies. The first has a family with young children, and the second has a family with adult children. Let me introduce you to a family with children under 18. Meet Luke and Sarah. They're a young couple in their 30s with two young children under 18. Sadly, Sarah has passed away, leaving her share in the home, superannuation, life insurance, and cash totaling approximately $1 million. If Sarah only has a standard will or no will at all, Sarah's assets will pass into Luke's name and be entirely exposed, particularly if Luke is running a business or enters into a new relationship sometime in the future, after a suitably long mourning period, of course. Under a standard will, there is simply no asset protection. If Luke does decide to repartner, there's no certainty that Sarah's inheritance will end up in the hands of Sarah's biological children. Sarah's inheritance will be at the mercy of Luke and potentially Luke's new partner and possibly Luke's future children. Conversely, if Luke and Sarah's children receive their inheritance via a TT, Sarah's assets remain in a protected trust environment for the benefit of Luke and Sarah's children. If Luke later dies, the trust can be managed by trusted family or friends for Sarah's biological children and even future unborn grandchildren, until such time that they're deemed financially mature enough to take over control of the trust themselves. We've all heard horror stories about children coming into too much money before they're ready, and they waste it. A TT will can prevent this from happening if it is managed appropriately. Importantly, the children can still benefit from the trust during their minority, but they will not have financial control over that money until they're ready. At the end of the day, we want to ensure our loved ones have options. We don't want our loved ones receiving a significant inheritance at a time they just happen to be going through a relationship breakdown or at a time they're being sued or are bankrupt. As you can see, the TT will put Sarah's family on the front foot and provides a lot more options to protect the inheritance, ensuring Sarah's legacy remains in her bloodline for years to come, creating life-changing, long-lasting, intergenerational wealth. Now that we've covered off on the asset protection, let me take you through the taxation benefits. If Luke invests his $1 million inheritance, he could conservatively earn a 5% average annual return. This means Luke could receive approximately $50,000 extra income on top of his salary each and every year. Under a standard will, however, the extra $50,000 additional annual income would be taxed in Luke's tax return on top of his marginal tax rate, potentially moving Luke into a higher tax bracket. Luke would also be paying for his kids' living costs, school fees, medical bills, sports lessons, and other extracurricular expenses with his after-tax income. Conversely, if the inheritance is received via a TT, the trust earns the income, and Luke is entitled to allocate close to $22,500 tax-free income per child each and every year. Luke can then pay for his kids' portion of the living costs, their educational and extracurricular expenses with tax-free income, allowing Sarah's inheritance to last so much longer. These tax benefits can be life-changing for a family that has experienced loss, and they are only available if you have a TT will. And when Sarah's children grow up and have children of their own, they can then apply the same tax-free income treatment strategy to their children. So this is generation upon generation of tax-free income advantages. This is why I am so passionate about TT wills. These wills can make a huge difference for the financial well-being of a family. Now, let me introduce you to a family with children over 18. Meet John and Anne. They have one adult child, Ben, who is married to Louise. John and Anne have both died, leaving a $1 million estate to their son, Ben. Here are 3 ways a TT will can protect Ben and his kids. If John and Anne only have a standard will, all of John and Anne's assets will be gifted directly to Ben and will be transferred and held in Ben's sole name. If Ben later dies, there's a high likelihood that Ben's will leaves everything to his wife, Louise. If Louise later decides to repartner, there's no certainty that John and Anne's inheritance will end up in the hands of John and Anne's biological grandchildren. John and Anne's inheritance will be at the mercy of their daughter-in-law, Louise, and the inheritance will likely end up being mixed up with Louise's new partners and possibly Louise's future children. Conversely, if Ben receives his inheritance via a TT, then Ben's will, and therefore Louise's will, is entirely irrelevant in relation to John and Anne's inheritance. Instead, the assets from John and Anne's estate will remain in a protected trust environment for the benefit of Ben and Ben's biological kids. As you can see, the TT will gives Ben and his children a lot more options to protect John and Anne's inheritance. If John and Anne only have a standard will, John and Anne's assets will literally be dumped into Ben's name, regardless of whether he is ready to receive them or not. If Ben just happens to be getting sued by someone, pursued by a creditor, or is going through a relationship breakdown at the time of John and Anne's death, or sometime in the future thereafter, John and Anne's inheritance will likely automatically form part of Ben and Louise's property pool to be sliced and diced by the family law courts. John and Anne's inheritance will also be exposed if Ben is running a business and is sued by a creditor or one of his employees. On the other hand, if John and Anne's inheritance is gifted to Ben via a TT will, the inheritance will not automatically form part of Ben's property pool in any family law proceedings if Ben and Louise later break up. The inheritance is also protected if Ben is declared bankrupt or if he is sued by someone. The TT will clearly puts Ben on the front foot and achieves John and Anne's asset protection objectives. Finally, John and Anne's child Josh and Josh's children and future unborn grandchildren will also receive the tax-free income advantages explained earlier. You really ought to consider incorporating a TT into your will if you are leaving at least $500,000 to one or more people. And when I say $500,000, that includes superannuation and life insurance. So it's really easy to get over this threshold. Or if you want to leave an inheritance to minors, including minor children, minor grandchildren, or nieces and nephews, or you want to protect your legacy from your intended beneficiaries' relationship breakdown, future repartnering, or bankruptcy exposure. Or you're worried about a beneficiary not being able to manage their inheritance. With all of that being said, a TT will is likely overkill if you plan on leaving everything to charity, you are leaving less than $200,000 to one or more people, you expect your loved ones to blow their inheritance up the wall, or you simply don't have any asset protection concerns and you don't care about saving tax. The bottom line is TT wills offer relationship breakdown protection, bankruptcy protection, they protect beneficiaries from themselves, and they offer fantastic income tax savings. If you die and you don't have a TT in your will, then your loved ones will miss out on these advantages. You must have a TT incorporated into your will before you die. A TT will is personally the will I have for myself because I've worked incredibly hard to acquire the assets I have, and I want to do everything in my power to ensure they end up with my intended beneficiaries. I hope I have demonstrated how simple yet powerful TTs can be. You've worked hard to acquire your assets, protect them, and leave a life-changing legacy with a TT will. You only get one chance, and there's no better time to create your TT will than now.